He has a lawyer, and that lawyer is planning to ask the court for a mental health evaluation to determine whether Gary Jr. is fit to stand trial. Attorney Arley Roberts has filed a motion asking Judge Rogers to allow him to file a motion requesting a competency evaluation under seal. That means we wouldn't be able to read it. Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental health condition and requests for psychiatric examination. These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition, the public disclosure of which would unnecessarily invade defendant's privacy and compromise the confidentiality of competency-related proceedings. Defendant seeks only limited sealing. Defendant does not seek to seal the entire case record, but only the competency motion, proposed entry that disclose or concern defendant's mental health condition, and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at issue, because the substance of the filing itself concerns defendant's mental condition and need for evaluation. Good cause, therefore, exists to permit the filing of these limited documents under seal. So in that motion asking for leave to seal the motion, Attorney Roberts makes it clear that he has highly sensitive mental health information related to his client's current mental condition, and he's making it clear that he wants him to undergo a
Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental health condition and requests for psychiatric examination. That is a direct quote from a motion filed in the Vinton County Court of Common Pleas. Translated from legal jargon, it means the man accused of fathering and endangering 16 children now claims his mind is too fractured to face what he allegedly did. The document asks the court to seal these records, not to protect an investigation, but to hide a psychiatric file.
Gary Jr. is fit to stand trial. Attorney Arley Roberts has filed a motion asking Judge Rogers to allow him to file a motion requesting a competency evaluation under seal. That means we wouldn't be able to read it. Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental health condition and requests for psychiatric examination. These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition, the public disclosure of which would unnecessarily invade defendant's privacy and compromise the confidentiality of competency-related proceedings. Defendant seeks only limited sealing. Defendant does not seek to seal the entire case record, but only the competency motion, proposed entry that disclose or concern defendant's mental health condition, and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at issue, because the substance of the filing itself concerns defendant's mental condition and need for evaluation. Good cause, therefore, exists.
Let that sink in. Before we go deeper into what the documents actually show, make sure you're subscribed to Beyond the Gavel file. Because we don't just cover the story, we follow the evidence. Picture a man standing in a room with no mirrors, holding a sealed envelope addressed to himself, while 16 locked doors wait behind him. That is the precise visual architecture of this defense. In one motion, the legal team for Gary Ciders Junior has simultaneously acknowledged that something catastrophic existed inside that house, while constructing a procedural shield to ensure we never see the documentation of it. The charges are 16 counts of child endangering.
Gary Ciders Jr. has been in jail in Southeast Ohio since June 30th. He's the father of the 16 children that sheriff's deputies and state agents removed from the house in Vinton County. Ciders' attorney is making a move that could bring his case to a screeching halt. You'll recall the conditions in the home were described as disgusting. The children, ranging in age from 1.5 to 18, all of them were largely off the radar for years, with the exception of a truancy complaint filed in neighboring Gallia County back in 2021. Gary Ciders Jr. faces 16 counts of child endangering. His wife, Elizabeth Ciders, faces the same charges. Gary Jr.'s parents, Gary Ciders Sr. and Christina Ciders, face the same charges. All four have pleaded not guilty. Now, the child endangering charge states that the children were abused and that the abuse resulted in serious physical harm. All of the children are in therapy.
Supported by allegations that the abuse resulted in serious physical harm to victims ranging from 18 months to 18 years old. Those are the hard edges of the complaint. But the defense response is not to attack the evidence of what was found. It is to attack the capacity of the man who was found.
Rogers entered a not guilty plea on his behalf. Gary Jr. at that time appeared to know enough to ask to speak to a lawyer. That is his right, of course. Now he has a lawyer, and that lawyer is planning to ask the court for a
The sealed document is the wound. This is a case study in how the legal system processes cognitive dissonance between survival instinct and collapse. The motion seeking leave to file the competency request under seal uses language of extraordinary sensitivity, describing content that would unnecessarily invade defendant's privacy and compromise the confidentiality of competency-related proceedings. Here is the structural irony beneath those words. The state will argue that this man deliberately evaded detection for years. The prosecution's theory requires planning, calculation, and continuous conscious effort to conceal 16 human beings from school districts, medical systems, and social services. Yet simultaneously, his own attorney is telling the court that his present mental state makes him incapable of understanding the nature of the proceedings against him. These two positions are not adjacent. They are chemically contradictory, and the court has to hold both of them to be true at the same time. The sealed document is the wound. The motion explicitly states that no less restrictive alternative would adequately protect the confidentiality interests at issue. That clause matters because it reveals what the defense fears most is not incarceration, but exposure of psychiatric records that might bridge the gap between the man who allegedly operated a hidden compound and the man who now requires evaluation before he can assist his own lawyer. Here is where the narrative splits into parallel tracks. On one track, 4 adults face identical charges: Gary Jr., his wife Elizabeth, his father Gary Sr., and his mother Christina. On the second track, Gary Sr. has already been ordered
therapeutic foster care. Gary Sr. isn't in great shape. He's the only family member who has been released from jail. He's receiving treatment for a serious medical condition, and the prosecutor has said he is not a threat to the public. A competency exam has been ordered for Gary Sr. because it appeared he didn't really understand what was going on during his first court appearance. Gary Ciders Jr., his son, is 36 years old, and he appears to be in much better shape physically than his father, who's 73 years old. You can see Gary Jr. here with his dad, as both were booked into the Southeast Ohio Regional Jail. Gary Jr. appears to move around just fine, and it didn't appear that he had trouble understanding directions from the corrections officers, although
to undergo his own competency evaluation after appearing so disoriented during his arraignment that the judge questioned whether he understood the proceedings at all. 2 generations, same house, same charges, same legal maneuver. This is not a coincidence. It is a pattern traceable through that single family address on Omar Street, and it raises the question: what atmosphere in that home could degrade cognitive function across multiple adults to the point that the courts now treat them all as potentially unfit for trial?
Do you think that this will be raised for the other defendants? And I'm asking you to speculate a little bit here, but we already have Gary Ciders Sr. Undergoing a competency evaluation. And I think we could all see during his arraignment that he's clearly seemed a little out of it and didn't understand what was going on fully. So I think that's a much different situation. We have an elderly man dealing with a serious medical condition, and we don't know what that is. But this is different. This is a man in his mid-30s who has fathered, as far as we know, 16 children, and he is accused of abusing them and causing, serious physical harm to these children. That's the charge.
The sealed document is the wound. A criminal defense attorney analyzing the case stated the quiet part aloud when she noted that
I have concerns that he doesn't understand what's going on. And so now a mental health expert is going to evaluate that and present a report to the court. How common do you think these competency exams are in criminal cases? Because I know throughout the years, as I've covered cases in court, competency has been raised in a number of cases.
Yeah, they are fairly done frequently, I would say, depending on the nature of the case. And like I said, there could be a complete disconnect between what is going on inside the mind of a defendant now versus what was going on at the time crimes were committed. And you have to keep in mind, in this case, the crimes they must have begun years ago. We've got 16 kids ranging from infant to 8 months to 18 years. That's a long time to live in that kind of squalor. And here's the one thing I will tell you that bugged me. I said to myself, well, he must be competent because this family knew how to evade detection.
This family knew how to evade detection. They knew how to hide. That phrase should echo. It reframes the entire defense posture because it introduces the unbearable tension at the center of this case.
Okay, so in all honesty, I'm not surprised because when you examine the facts of this case, this is like no other case I think we've analyzed in my career. Like, this is a really strange case with the level of neglect that went on with so many children for so long. Now, here's the one thing that I think our viewers have to keep in mind. A competency hearing or a competency determination is not the same as insanity. And a lot of people will confuse the two. So competency, why it makes sense here is because it's to gauge whether or not at the current time, so it doesn't look back really to the history, at the current time, does the defendant understand the proceedings and can he assist in his own defense? So we can probably make a short leap between, well, all right, there was a lot going on here for a long time that probably that indicates this defendant had deficient mental capacities. And now here we are facing several felony charges. And does he get it? Does he know where he is? Does he know what a court proceeding is?
How do you argue mental incompetence now for a man who maintained operational security over 16 children for years? If he was lucid enough to keep that many lives off every official radar, then the competency motion becomes something far more calculated than a medical necessity. It becomes a strategic exit ramp built from the very material the prosecution needs to establish motive and culpability. And still, the charging document reveals another layer buried inside the motion for continuance in a separate public indecency case. 4 misdemeanor counts allege that Gary Jr. exposed himself to someone who was not a family member between May 23rd and May 31st of this year.
Decency. He's accused of exposing himself to someone on 4 occasions between May 23rd and May 31st at the home on Omar Street. The complaint says the person Junior exposed himself to was not a family member. Now, this may be part of the reason, this competency issue, why Gary Junior's attorney asked for a continuance in that public indecency case just recently.
Those dates matter because they place the alleged conduct immediately before the removal of the children. The state's timeline now includes not only the neglect charges but a separate category of behavior that suggests impulse control so absent that it manifested in view of a non-family witness. His attorney requested a delay in that case specifically to address the competency issue. The court granted it. The signal is unmistakable. The defense wants to consolidate every accusation under one umbrella of mental incapacity, and if that umbrella opens wide enough, criminal accountability evaporates.
Do defendants ever feign incompetency during an evaluation or fake it or try to exacerbate symptoms?
Yes, and very often psychologists will use instruments to detect that malingering or feigning that you're describing, which is not uncommon and for obvious reasons why they wouldn't want to be found competent to appear in court.
So what are we actually looking at when this sealed motion arrives before the judge? A forensic psychiatrist performing a competency evaluation will apply a 2-pronged test.
No, it doesn't. In the state of Ohio, people are presumed to be competent, and competency can be raised by either the prosecution, the defense, or the judge themselves. So in this particular case, what we're looking at is the defendant's present state of mind. Distinguish that from their state of mind during the commission of the crime, which would be a sanity evaluation. And so we're looking at a 2-pronged test. We're looking at if the defendant is able to understand the nature and the objectives of the proceedings against them, and they're able to assist in their own defense. So if they are deficient.
First, does the defendant understand the nature and objectives of the proceedings? Second, can he assist in his own defense? If he fails either prong, he is declared incompetent. If restorable, he will be committed for treatment for up to 1 year on serious felonies. If not restorable and the court finds clear and convincing evidence of guilt plus ongoing danger, he could be civilly committed for the duration of what his maximum sentence would have been.
To be found incompetent. Then the court looks at, is he incompetent but restorable or not restorable? If he's incompetent but potentially restorable, he would be committed to a psychiatric hospital or some outpatient facility where they could try to restore his competency and potentially receive involuntary medication. And generally, with serious felonies in the state of Ohio, that could be up to a year. If he's incompetent but not restorable, then at some point he may be committed civilly to a psychiatric hospital if the court believes that he's guilty of the crime by clear and convincing evidence and he's still a danger to the community, that he could be committed to a psychiatric.
This is the mechanical framework, but the human question underneath it is far more disturbing. What does restoration look like for a man whose entire defense hinges on the assertion that his mind was never fully operational to begin with?
Disorder. That doesn't per se mean that you will be found incompetent. So it's really about your present state at the time and if you're able to understand the proceedings in the court and work with your attorney. Some of these skills that we're talking about, for example, would be knowing the roles of the various courtroom participants, knowing the role of the prosecutor and the defense attorney. So, for example, a question we may ask is, can the defense attorney and the prosecutor ever switch places? We're trying to make sure that the defendant and their constitutional rights are protected.
The sealed document is the wound, and it remains sealed, not redacted, not partially released, sealed entirely. The public is told that the children are in therapeutic foster care.
Well,
It's going to be such a long road for these kids, and probably even worse for the older ones. I think the oldest is 18 years old. And if that child lived, since we have no records, like some of them, so if that child lived his or her entire life without reading, writing, arithmetic, without proper nourishment, with bacteria, with feces, with disgust, with not being socialized, that's hard. At least the younger ones, I think, have a little bit of a fighting chance if they get into really good foster care. And there are some really good foster parents out there. So fingers crossed for that.
That phrase carries its own weight. Therapeutic foster care is not standard placement. It signals that these children require clinical intervention to process environments that shape them before they could speak or write their own names. They are the living evidence that something was broken long before anyone entered a courtroom. Their conditions remain protected by HAPA. Their futures depend on what the state can prove about 4 adults who all entered not guilty pleas while simultaneously arguing that 2 of them may lack the basic cognitive tools to participate in their own defense. We have reached the phase where the competency motions rewrite the timeline. Gary Ciders Junior remains in the Southeast Ohio Regional Jail on a $300,000 bond. His wife, his mother, the same bond. His father, the only one released, is receiving treatment for an undisclosed medical condition that a prosecutor described as making him no threat to the public. The house on Omar Street is empty now, but the docket is not. A grand jury has not yet returned indictments. We do not know what additional charges may follow or against whom.
to see this raised in the other cases, because Jonna, we're really at the complaint phase of this case where they've waived their preliminary hearings. We haven't even seen an indictment yet. We don't know what charges that will be indicted at grand jury and presented and requested at grand jury. We know it will likely be child endangering, but how many more and who gets indicted for what? That's still an outstanding question.
We only know that the man at the center of this case has asked a judge to hide his mind from public view, while his lawyers prepare to argue that mind was never able to form criminal intent. Before you close this file, pull the docket entry for State of Ohio versus Gary Ciders Jr. in the Vinton County Court of Common Pleas, case number 20, for CR 0041. Read the motion for leave to file under seal. Then ask yourself in the comments below, if the same mind that allegedly operated a hidden household for over a decade is now being declared legally incompetent, which version of that mind is the real one? And what happens if both versions are telling the truth? Make sure to like, share, and subscribe to Beyond the Gavel file with notifications turned on. We will be here when that seal is challenged.